Yes, Mr. McDonald.
Tab 26 of the supplemental bundle, I think, is where we were.
Yes. Yes.
My Lord, at the trial, I put it to Mr. Sargent that I asked him to explain this email, and he said he couldn't understand what he was, at this stage, he couldn't remember what he was trying to say, and I suggested to him that what he meant at the time when he sent this email to Kingston Smith was that the four-man partnership, which had been notified to the revenue on the 4th of April for the purposes of securing group VAT treatment, was now a 5-person partnership because my client had become a member of it, and that's why he said to Kingston Smith that it no longer had 25% voting share splits. But he insisted that he couldn't remember what he had meant at the time. He didn't deny what I was putting to him. His position in the witness box was he just couldn't remember at all, and on that basis I relied on that. The judge did not base his conclusions on that. He refers to it and he expressly declines to rely on it for his factual conclusions. We wrote to our appellants when we received those documents from them, and I've checked the correspondence, and the new documents did include the email from Mr. Sargent and the what he calls the attached letter from HMRC. So it doesn't appear that we had them before November. We wrote a letter which we regard as important. We relied on it to some extent in response to my learned friend's pleading points, but it's not a full answer to them. But we've moved on, I think, on that. The letter is still important. It's at page 184 of the agreed core bundle, in the sense that it's quoted in my skeleton argument. In our skeleton arguments at tab 14 of the core bundle and paragraphs 11 of the skeleton argument, page 184, says by the time of the trial further documents had come to light which showed that in order to obtain group registration, etc., and my lady and my lords are familiar with the rest of that. But then in paragraph 12 we say, on the basis of those documents, Richard Slade wrote a letter to the appellants on the 15th of November. Mr. Sargent's email to Mr. Barker on the 21st of June shows that he had read and understood HMRC's letter of 14th of June, and that his own view was entirely in accordance with our own client's view of the position. Mr. Sargent's own view at that stage was, I would have thought it's the partnership that owns the limited company, which no longer has 25% voting share splits. In other words, the limited company, whose shares are legally registered as to 25% each in the names of Sargent, Martin, McGloin and Beaton, is actually now owned beneficially by a partnership consisting of Sargent, Martin, McGloin, Beaton and Keane. Mr. Sargent clearly thought that was already the present legal position on 21 June, which should be relied upon to satisfy HMRC and secure group registration. Kingston Smith viewed it slightly differently at that stage. When they replied to HMRC directly on 26 June, they said Document Risk Solutions Limited and Derivatives Risk Solutions LLP are both controlled by the four individuals in partnership and therefore form a group for VAT purposes. The important point for our purposes is that Kingston Smith also thought, like Mr. Sargent, that a partnership holding the shares in Document Risk Solutions Limited was already in existence. The only difference between them was that Kingston Smith thought that a written partnership agreement should be put in place, and when they got round to that, they decided that the written partnership agreement should be made by the four original partners, and that our client should join it by a deed of adherence. These documents now appear to make our client's case irresistible. If you do not agree, please explain why not. There was never a substantive reply to that letter from the appellants, but it made clear to them 3 months before the trial how Mr. Keane's case would be presented, and that was entirely within the scope of his pleadings.
Sorry.
The feedback is getting worse.
My Lord, if you'll forgive me, I apologise. I'd forgotten to put these headphones back on.
Do you think that makes a difference? It may do.
Well,
We had a screen up before with the CVP connection, which we don't have
I
now.
think they may have tried to reduce it as doing that. Yes.
I think it might be better if you turn it back on again. I think it seemed to be okay before lunch.
It seems to be, my lord, it seems to be indicating that it is on.
No, it's not the live streaming. Live streaming is one thing. This is CVP, which is to make sure that Mr. McDonald can hear. Because if he was looking at the live streaming, he'd be 90 seconds behind, which would make the whole case very confusing.
yes, I did try that the other day, my Lord, and I noticed that.
You'd be answering my questions from 90 seconds ago, which wouldn't work.
Yes. Lord, I'm very sorry about this. But
No, it's fine. You carry on. I think it's got better.
Better,
You
yeah.
keep going.
And
I think my lord had a question for
I
you.
did have a question. Mr. McDonald, you alluded to this, but the judge says in paragraph 220, talking about the email, it would not be right to conclude on the balance of probability that the reference to the change in percentage split reflected the effect of Mr. Keane's addition to the partnership.
yes,
So is that challenged?
no. Well, it's not challenged in the sense that I accept and seek to commend to your lordships the entirety of this very intricate judgment. I wish he had accepted that. In the end, it didn't matter because we got to the right answer. Lord, one of the things that helps one to find one's way through the intricacies of the judgment is the very elaborate headings which the judge introduced and which were probably of assistance to him. They're of less assistance to us unless one prepares a tabular summary of them, which I've done. But what I'd like to take your lordships to is para 235 of the judgment, which is in the heading G5, was there a partnership as at 18 June 2012? That heading is on page 99 of the bundle, just before para 232. And this is a passage of the judgment which is foreshadowed at para 184. Page 89. And this is part of the judge's discussion under the heading, does the case at trial fall outside Mr. Keane's statements of case? That's at the top of page 88.
But 235 builds on 234, and what may be helpful to understand is what was the evidence to support those earlier agreements, the interlinked agreements.
May I come back to that, my lady? I mean, I'll go straight. I'll answer you straight away, very briefly, but I'll try to then come back to what I was going to say.
Well, so don't go out of your course if you don't want to, but it would help me to understand what you say about that.
Well, para 65 this is a key finding of fact, as it turns out, that it begins simply by referring to an email. So we're in the realm of documentary evidence.
So which paragraph?
Sorry, my lord?
Which paragraph?
65.
65.
It starts at the bottom of page 62.
Yeah. Yeah. By
email sent to Kingston Smith on the 27th of April, presumably after the meeting with Mr. Keane rather than during it, but that matters not. Mr. Sargent provided details of the general package agreed, and the judge has underlined agreed with Mr. Keane, and he indicates this is going to be important in what follows by defining it as the agreed general package. It was not written whether this was derived from previous conversations between Mr. Keane and Mr. McGloin. Again, however, that doesn't matter. Mr. Sargent, acting on behalf of the other defendants, plainly recorded their acceptance of the fact that the agreed general package was in place. Mr. Sargent, an intelligent and careful lawyer, would not have referred to the package being agreed without meaning it. Perhaps the court should have a finger in the email being referred to, and that's in the supplemental bundle. tab 22.
This isn't the agreement the judge found, is it?
Hmm?
This is not the agreement the judge found.
Well, he found that this was agreed, and that the terms of what had been agreed were developed in the course of the negotiations that continued.
Can I just ask a further question on that? Is it, as you read the judgment, was the judge finding that there was a contract at that stage?
Yes.
And how was it agreed?
How?
How was it agreed?
It was agreed at meetings and individual conversations between meetings of the 4 defendants and my client, and individual discussions between individual defendants and my client, including Mr. McGloin. But the point about the email of the 27th of April and the importance of that is that that's the email that the judge founded his contractual structure on. Is that having had a meeting earlier that day with Kingston Smith, at which my client was also present, Mr. Sargent, around lunchtime, emails Chris Hughes, who's the partner in charge at Kingston Smith, and his assistant Chris Barker. And the subject of the email is new member Gary Keane. And that in itself is noteworthy. Many thanks for your time earlier. Glad we're making good progress. Below is the general package we have agreed with Gary. And the expression, the general package, indicates that it covers the whole subject matter of the agreement or potential agreement. And it says, we have agreed this general package with Gary. And then financial for the first 6 months, you'd be entitled to, etc. At the initial 6 months point, we'd all have the ability to walk away if things are not working out as expected. After the initial 6 months, assuming you met the performance criteria, you receive 12.5% of DRS profits, and on the anniversary of your joining, your share would rise by 7.5%, with the aim that you would have equal parity with the existing directors after 12 months.
Why does he use the word would? You would be entitled, we would all have, you would receive, etc.
Well, you notice the quotation marks, my lord. This is a quotation from an earlier email to my client.
That still used the word would.
Yes.
My lord's question is why?
Well,
If it was agreed, wouldn't it say will?
Not necessarily, my lady. That's what I would say, isn't it? But I think the earlier email was certainly in the trial bundles. I don't believe it's in the supplemental bundle.
The March one is.
It is.
Is it?
It's,
The 21st is behind that. So,
223
223.
get the email of the 1st of March
Yeah.
with the revised general package, if we get to call it that,
Oh,
offering,
yes, yes.
which is then reflected in the later email.
Yes, well, this is an email on the 21st of February, before, long before it could have been described as agreed.
Well, I think, in fact, I don't think it affects your point, but Mr. Sargent has put into an email of the 1st of March an updated version of the earlier email, I think.
Yes, I remember that. I don't know whether we... Yes, the further update is tab 19,
Yeah.
which shows the amendments in bold. And in this one, he not only doesn't use the word would, he does. Firstly, we are happy to agree that subject to the performance criteria being met, the increase in both profit share and equity increases at a higher level than previously, such as you would achieve parity at the first year anniversary of your joining. Would make sense there because, of course, it's subject to the performance criteria. So, in other words, you make an agreement, the parties to which are all contractually bound into C, under which the incoming individual joins the business on the basis that if he performs satisfactorily, and that there are criteria for that in another document, if he performs satisfactorily, then he will become a member of the firm, to put it neutrally, at some time in the future.
That works to an extent, but not, for example, for the first two bullet points under financial, I think, because those don't depend on the performance criteria. So it says for the first 6 months you would be entitled, and that's not dependent on the performance criteria. And at the initial 6 month point, we would all have the ability to walk away.
But this is a pre-agreement email. So the email of the 21st of February in tab 18 of the supplemental bundle.
But it's in exactly the same terms as the 27th of April
Yes,
email
because
that
the later
you rely on as a contract.
Yes.
Well, the point you can make, Mr. MacDonald, in your favour, is that in the precursor to the 21st of February email, it says before the terms, with this in mind, we suggested a package comprised of the following, and in the precursor to the later email, which I think is at 234, I may be wrong about that.
No, right, you're right.
It says we have agreed, yeah.
It says we have agreed the package. So on one analysis, they were talking before in February about a general package they had suggested to Gary, and now, but I think to the same people, can I just check that? And Yes, no, not to the same people,
Kingston
but
Smith.
to different people. They're saying we have agreed.
Yes, and what's more, the text that follows the words "we have agreed with Gary Cohen" begin with a quotation mark, which indicates that they're a quotation from an earlier document, and that earlier document is
The amended version.
yes, tab 18.
Okay, can I try something slightly different? Mr. Sargent said, well, this was an outline proposal. Supposing that to have been right, and that Mr. Keane had agreed the outline proposal as something that would then be carried forward into detailed documentation by way of contract, would any of this have been different?
Would the wording of any of these documents have been different?
Yes, I mean, supposing that Mr. Sargent at the time had not thought we've entered into a contract, but had thought this is a proposal which we've agreed with Gary, which is going to be taken forward into detailed documents. Might he have said the same things?
He might have done, yes, and that was one of the questions the judge had to ask himself. But the judge deals with it at para 66 of the judgment.
He rejects Mr. Sargent's evidence, but you didn't cross-examine about it, did you?
I can't remember.
Well, that's what we've been told.
The transcripts are here, and one of the things that I would have done over the long adjournment, had we not moved quite quickly this morning, is check that. I can check it.
Well, it was in Ms.
I can check
Anderson's
it
skeleton argument.
I can check it right now if your lady would like me to.
Well, I mean, if you look at the words of paragraph 66, the judge is actually using quite interesting language. He says, Sargent described the agreement as an outline proposal. We don't accept that description. It was an agreement which was open to further discussion and variation until Keane joined. However, at that stage, it set out the agreed terms. If nothing changed, they would be contracting on that basis.
Yeah.
So he's almost saying the subject to contract point that my lord put to you.
Well, subject to contract is an expression with particular legal consequences, which is generally not used in discussions or negotiations between non-lawyers. But
Well, I suppose they were accountants, not lawyers.
no, they were solicitors.
Oh, they are solicitors. Kingston Smith is solicitors.
No, sorry. Kingston Smith are accountants, and defendants 1 to 4 are
all
solicitors.
lawyers.
Yes.
Anyway, there we are.
I mean, just take it one stage further. Supposing that was what Mr. Sargent was thinking, he wouldn't need to stick in subject to contract when writing to his accountants.
No. I'm just looking to see how the email ends. Yeah, he doesn't do anything other than set out the terms of the previous email to my client, setting out an offer. I mean, the common sense way to look at it is that Mr. Sargent is here after an important meeting with Kingston Smith that morning. He is informing Kingston Smith that they have agreed the following general package with Gary.
And then your problem, I mean, let's assume for a moment you're right and that this is an agreed general package. They go to another meeting which is avowedly on the evidence to sort out the details. The only evidence the judge had was from the defendants, which wasn't cross-examined, as I understand it, which was that he said no, and the judge accepted. He said he didn't want that arrangement because of tax.
Yes.
So where does that leave the agreed package?
Well, the judge, of course, found that Mr. Keane's statement that he didn't want to take the shares as such, and in reality, if he'd understood the tax point properly, which he may or may not have done, the point was the point that he would incur a tax liability is becoming a director.
Yeah, but what I'm worried about is the evidential position. He accepts that he said he didn't want it if there was a significant, the judge says, adds the word significant, but if there was a significant tax liability.
Yes, and the judge, in a few words, seeks to explain why he's added the word significant.
Yes, but the only evidence on which the judge could rely was the evidence of the defendants. The claimant doesn't remember at all, where they said he said he didn't want it at all. And so if he's rejecting the package, where does it leave the package? I mean, your case and the judge's finding really is that it leaves the package in place. I don't understand exactly how.
Well, it was never replaced by another package.
Well, it was on the judge's own finding. I mean, the judge said it was replaced by another package which didn't have the conditionality.
Well,
it doesn't tell us when.
And the deadline is the entering into the LLP.
18th of June.
Yes. And well, don't forget that we mustn't overlook the fact that on the 14th of May, the entire business and assets of DRS was transferred into the LLP. So DRS, in a way, ceased to have an immediate function at that point. But the judge...
Why does that matter?
Well, the judge appreciated that the point of the LLP was that you transfer everything, all your company's assets, into the LLP, and then you get them back out of the LLP into the company in a way that is only subject to 10% tax. And so in a way which is described in detail by Kingston Smith in their...
I understand, but why does it matter in terms of identifying what was agreed as the replacement package?
Because the LLP agreement only worked if the limited company belonged equally to the 5 general partners. And if it didn't, then given the long-term plan under which you put everything into the LLP on the 14th of May 2012, but then after a year and a day, you start clawing it back into the limited company, making very large tax savings as a result.
So you mean the tax scheme only worked? The LLP agreement worked. You're saying the tax scheme may not have worked. Is that what you're saying? I'm not. I'm maybe being obtuse.
What I'm saying is that once you bear in mind the purpose of moving into an LLP, which all these parties knew and had been explained at great length by Kingston Smith, it only worked as between the 4 original members and my client, as the 5 general partners of the newly formed LLP. It only worked if the original limited company into which all the value was going to be transferred back after a year and a day belonged to the 5 of them.
Can I follow that up a moment? It worked for the 4, regardless of whether the 5 owned the company, didn't it?
Yes.
The 4 were quite happy that Mr. Keane should be included as well.
Yes.
And they were very surprised when, at the 10th of May meeting, he says, I don't want the shares.
Yes.
So you ended up on Miss Anderson's case with an arrangement which worked for the 4 perfectly well. And the fact that it didn't work for Mr. Keane was his choice. But even then, he didn't have to enter into any of the members' interest purchase agreements. He could perfectly well have said, no, I'm not selling any of my interest in the LLP to the company.
Yes, and if he'd understood it in the way the others did, he no doubt would have done. But what the judge found was that after the meeting of the 12th of May, at which Mr. Keane said he didn't want to become a shareholder and director of the limited company, Kingston Smith and at least Mr. Sargent began thinking about another way of doing it, which was to form a partnership. And the judge finds at one point in these paragraphs, I hope I'll come to it in my scheme of the paragraphs I'm going to be referring your lordships to, the judge accepted that as part of the factual story that explained why we are where we are today.
But the partnership was formed before. It was formed on the 4th of April. That's what the VAT...
Indeed.
So that was before Mr. Keane rejected
Oh, yes,
the
yes,
arrangement.
yes. But that was just a partnership of the 4
Yes.
directors.
So they weren't forming a partnership in order to deal with this problem.
No, but they had a partnership to which they could use to deal with this problem.
Yes.
By admitting Mr. Keane to it.
But he never signed.
Admitting him in a rather funny way, because as I understand it, the partnership property was going to be the shares. Mr. Keane didn't want an interest in the shares, or might not have wanted an interest in the shares. So it isn't a straight, you accede to the partnership and then have an equal share in the partnership assets. It's the other 4 own the partnership assets, and you just have a right to a profit share. Now that's quite possible, I dare say, but it's not normal.
The partnership assets are simply the 4 25% holdings adding up to 100% of the shares of DRS Limited. That's all they needed to own back on the 4th of April when they worked out how to get group VAT registration. The very complex provisions of the LLP agreement, which were explained to all of them by Kingston Smith, and which it doesn't look as though my client really took in detail. The LLP agreement is merely the LLP is merely a temporary expedient to enable large tax savings to be effected by all the business being put into the LLP and then clawed back with the very favourable tax consequences, which Kingston Smith explained at the very beginning of this story. And I mean, that's why the MIPA, the first MIPA, which was the first move in clawing back. The date of it is just one day after the anniversary of the forming of the LLP, so one can see there's a long-term plan understood by Kingston Smith and possibly by the 5 members.
Just coming back to the 10th of May. On the 10th of May, on the judge's findings, there was a partnership with 4 partners who held as the partnership assets the shares in DRSL. If Mr. Keane simply acceded to that partnership, then that would give him an interest in the shares in DRSL,
Yeah.
which he didn't want.
No, it wasn't offered to him. What was explained by Kingston Smith was that if Mr. Keane became a legal shareholder, let's say a registered shareholder, a member of DRS and a director, he would be charged by the revenue on the basis of having acquired an asset to be valued on the basis that he'd be charged on the basis of having achieved a profit to be measured by subtracting the par value of the DRS shares from a valuation of a 20% holding in DRS. And so if DRS was worth £2 or £3 million by 2012, which it seems to have been, then Mr. Keane would be charged apparently straight away on a fifth of £2 or £3 million less £20 par
So
value.
you're drawing a distinction between the legal ownership and the equitable ownership.
Absolutely.
But is there any reason to suppose that Mr. Keane, when he says, I don't want the shares, was drawing a similar distinction and saying, well, I don't want the legal ownership, but I'm happy to have some beneficial ownership?
All Mr. Keane was saying was, I don't want to pay that tax. I've received some instructions from Mr. Keane. I think it'll do no harm if I tell you what they are. He received an email advising him to refuse to accept the shares from Kingston Smith in the morning of the 10th of May. I think we know what that is. This is a typical piece of, as it were.
Sounds like a waving of privilege to me. But anyway, I mean, I'm not sure we're taking account of that kind of instruction at this stage in the case.
What he's referring to is the email, what was called the one-pager that everybody was expecting from Kingston Smith, explaining why there would be a liability on Gary if he took these shares.
Came on the morning of the 10th of May.
Exactly, 20 to 9. It was in the trial bond.
Yeah.
I'm just trying to think where I am, but I'm at the general package we have agreed with Gary in tab 22.
Can I ask you one question about that then? If we look at that general package, which bits of that do you say ultimately became part of the agreement?
19th of June.
Yeah.
18th of
On the
June.
18th of June.
Yeah. Well, you would have, after 6 months, assuming the performance criteria had been met, you'd get a further 7.5, with this rising on the first anniversary of you joining by another 7.5. So with the aim, you would have equal parity with the existing directors after 12 months.
But you say that didn't happen. You say there was parity from the start.
Well, in the end, yes, there was parity from the start because, first of all, at some point in May, it seems to have been accepted that these requirements have been met. I think, I can't remember the date on which Mr. Keane actually joined the firm, the company physically. I think there was an email from Mr. McGloin to the staff saying a new managing director, Gary Keane, will be starting, I think, on the 1st of May, something like that.
So I don't understand. Are you saying that the performance criteria that were due to run for a year were met within that month or two?
They were just abandoned.
They were abandoned?
Yes.
Right, so when was that agreed and how and what is the evidence for it? Mr. Keane didn't say anything about that.
No, it's just what happened.
Well, what's the evidence for it?
Well, presumably, I mean, this goes back to a comment made at the beginning of my skeleton argument, which is that we're entirely dependent upon the emails, but the emails are patchy.
And there are 4 defendants who reject that case. So
Rejected what case, my lady?
that there had been an agreement to enable equal parity immediately. And
I didn't say that there was such an agreement. What I said was that the equal parity, the performance criteria were simply abandoned.
Well, let's just analyse that for a moment. Let's assume that that's the case, that there was an agreed package on the 27th of April, and the package was varied as an agreement can only be varied. You can abandon an agreement, but you can only vary an agreement. You can't just abandon a bit of it, not technically. So you have to show that the time came when the criteria, the performance criteria in the financial general package was varied. It was agreed that they would no longer apply, and 25% would be acquired immediately.
20%.
20%, forgive me.
20%.
Now, the question is, agreements do not appear out of the ether. They are the function of the parties to the agreement doing something, right? Now, what I think my lady's asking, and what I'm keen to find out, is A, what the judge said about that. In other words, what was the act, whether by conduct or writing or orally, that led to the performance criteria being abandoned, or the variation of those criteria to be excluded, and how did that happen between the 10th of May, when he said he didn't want any shares, and the 18th of June, when the judge said there was an agreement in place for him to join the partnership?
Well, what happened on the 18th of June was that the LLP, as it were, or in some sense, was treated as coming into.
It was held in escrow, no doubt, and then the parties said it's now agreed.
Well, the LLP, in fact, of course, had come into it had come into legal existence at some date in April when it was registered. That's, I think that's
yes,
common.
the LLP was registered, but not the LLP agreement.
The LLP took over the business
Yes, in April.
at midnight on the 14th of May, I think.
Don't know.
I mean, if it matters, I can.
Well, it probably doesn't matter, but what there must be somewhere, either in the judge's judgment or in the evidence, some indication of why the agreement by way of general package made on the 27th of April was varied to exclude the performance criteria. I'm not just being a technical lawyer.
No.
You just don't have agreements that change by magic.
No, but you can have an agreement which, part of which is tacitly, but by common consent of the parties, simply
Yes, but the consent,
not informed.
the consent has to be manifested in some way. You know, it's not possible just to have it done without anybody saying anything. So if we look at the word abandoned in the judgment, in paragraph 209, the judge said, it follows that I do not accept the defendant's case that the parties abandoned the concept of two interlinked agreements. So that's not the point there. So he didn't actually hold that these terms had been abandoned. I'm not quite sure what he did hold. We need to look at...
He also finds that the agreed general package was not varied.
Yes, he says in 209,
Yeah.
there's no evidence that renegotiation, variation or termination occurred.
Yeah.
209.
Follows that I don't accept the defendant's case that the parties abandoned the concept of two interlinked agreements, that's to say the
But
agreement.
that puts the cart before the horse. What he needed to say is, how do you get from the 27th of April contract, as you've described it, to a different arrangement that didn't have performance criteria and in relation to which Mr. Keane would get an immediate 20% share without variation, renegotiation or termination? And that's really what we're asking you to help us about.
Well, the judge helps us about it in paragraph 211 in the passage your ladyship is looking at.
Mm-hmm.
Evidence establishes Mr. King's 10th of May statement was not the final word. It's plain, and I find as a fact, as explained below, that the parties decided, whether at the meeting or afterwards, it doesn't matter, but probably at the meeting. So the judge is finding that this was decided by the parties, but he doesn't know exactly when, to investigate methods to achieve the equal parity agreement without producing a significant tax liability for Mr. Keane. Now, I reach that finding not only because of the deficiencies in the defendant's recollection, see the summary below, which I'll come to, and or because investigation as opposed to termination was the most probable outcome, see 85 to 91 above. Now, keeping a finger there, may we look back at 85 to 91. He said the fact that the defendants have misremembered important matters occurring between the 1st of March and the 10th of May as set out above.
Well, and the important matter, I'm so sorry to interrupt you, is that there was a contract in relation to the 27th of April. Is that right?
Yes. Well, there was a contract as found by the judge and as...
That's what they're forgetting.
Yes. The fact that they've misremembered important matters doesn't necessarily mean their recollection of what occurred at the 10th of May meeting will be unreliable. However, it emphasises the need for caution and the importance of contemporaneous documents, and they, of course, were incomplete. On the other hand, Mr. Keane at trial no longer disputed that he said he wouldn't take the shares with a tax liability. He recollected during cross-examination that this flowed from the content of Kingston Smith's email earlier that day. I think that was the point my lay client was trying to remind me of. Miss Anderson relied upon this as establishing that Mr. Keane's claim must fail. I don't agree that this is the inevitable conclusion as she proposed in her final submissions. The evidence in the case of the defendants that his statement was a final decision that rejected their 1 March offer of parity needs to be addressed further for 3 reasons. First, because their evidence, including their conclusion, is based upon their incorrect understanding that there was only an outstanding offer, and therefore that the parties were not proceeding on the basis of 2 agreements, namely the agreed general package and an LLP agreement. So the judge hangs on to his finding that the agreed general package was an agreement or contract in my law, which I think is the term my Lord would prefer me to use. Secondly, though directly connected, the concept of the equal parity agreement rejected potentially jars. In particular, the fact someone says they don't want the shares with a tax liability does not necessarily mean subjectively or objectively they reject an existing agreement of equality. It could simply mean that they want the position further investigated and for the agreement to be varied to avoid a significant tax liability so far as that's necessary.
But I mean, all this, Mr. MacDonald, not wishing to interrupt, but we've read ahead. I mean, all this is simply justifying what is really obvious and probably not contested, which is that after the 10th of May, when Mr. Keane said he didn't want shares with a tax liability, they went away and drafted something different.
Yeah.
And put it up for consideration, which is what happened. But in order... Yes.
Is your Lordship referring to the partnership documents which emerged in August or something else?
No, I'm referring to the... Well, yes, that's right, but they went away and drafted partnership documents and an accession deed, which suggested something different. But what the judge found was that by the 18th of June, which is not long after the 10th of May, it's just a month and a bit, there had been a variation to the agreed package agreement, whereby the conditional criteria were varied and removed. Now, what I'm asking, and I don't think the answer is in 86 to 88, which simply justifies that they went away to think about it, but the answer must be in the section headed the events between the 10th of May and the 18th of June, which is back in 209 or something like that. Yeah. 213. And it says it's not easy to identify precisely what happened after the 10th of May meeting. Mr. Keane doesn't remember. And the findings of fact based on contemporary documentary evidence are inconsistent with the recollections of the defendants. And then he says, well, that means they that is because they didn't remember the agreements they'd reached. This is at paragraph 213. And then he goes on, but what I can't find, and you'll point me out where I can find it, is between those paragraphs up to 218, where does he say the manifestation of the variation took place? Because if not, it's missing.
Well, at 209, he expressly finds as a fact that the equal parity agreement was not renegotiated and the agreed general package was not varied or terminated at the 10th of May meeting.
Correct.
And there's no evidence that renegotiation, variation or termination occurred.
But that's not right, because he then makes a finding further on at 200 and, I'm sorry, I'm not as familiar with this obviously as you. Was there a partnership as at the 18th June, starting at paragraph 232? He says those facts and matters, this is at 235, lead to the conclusion that on the 18th of June, the parties entered into two interlinked agreements, the LLP agreement and the agreed general package subject to its variations. So he had not found that there were no variations, he found there were variations, but never tells us when those variations were agreed. And my reading of the evidence is there is no and was no evidence of that.
No, he had to decide what happened on the balance of probabilities.
You need evidence.
On the basis of unreliable oral evidence from all the parties.
I mean, as Lord Gough said in one of my favourite cases, the name of which I'd forgotten this morning, the Ocean Frost, he said if all the parties are lying, he didn't use these words because he was far too circumspect, as you will recall, Mr. MacDonald, but he said if all the parties are lying, you look at the documents, and that will help you. And here the judge did look at many of the documents, not because the parties were lying, but because the parties didn't remember a thing. And you still need something to add up to the variation found in line 3 of paragraph 235.
Well, the basis of it is the judge's duty to find out on the balance of probabilities what actually happened.
But is he guessing? Is he, I mean, what, he can't guess, he can't speculate.
Yes, he can.
Really?
Yes, my lady. May I go back to the beginning of my skeleton?
He can guess and speculate, he doesn't need evidence.
Well, my lady, I was dramatising my answer to your lady's question, but the
I mean, I quite accept he can draw reasonable inferences from the facts, but you do need to have an evidential basis for the inferences you draw. And what I'm struggling with, and I think my lord has been struggling with, is where is the evidential basis?
Would your ladyship go to my skeleton in the core bundle at page 187? Which makes the points which I was crudely summarising in the answer I just gave my lady. The judge's findings of fact, this is para 21, as to what was agreed between the parties were based on, one, their evidence in chief as contained in their witness statements and the oral evidence which was given by each of them under cross-examination, and two, the documentary evidence which was in two categories.
So just pausing there, the oral evidence given by the parties, Mr. Keane gave no evidence about a variation, and the four defendants gave evidence that Mr. Keane rejected the agreed package in effect by rejecting the taking of the shares. on the 10th of May. They were very surprised, but there it was. That was their oral evidence. That was their witness statement evidence. So that doesn't help you, does it?
Yes, it does, my lady, because, and it helps me in the way the judge explains, because what the judge found was that the position of Mr. Keane was that he was not prepared to take an interest in the DRS shares that involved a significant tax liability.
Yeah.
That doesn't mean he didn't want an interest in the DRS shares. It meant it would have to be achieved in a way that didn't involve the tax liability.
Well, that's not evidence that there was an agreed variation.
Well, with great respect, my lady, in the context of negotiations between parties like this, I would say that that would amount to an agreed variation in due course if they found another way, which they did.
Well, can I, I'm sorry, this is a slightly boring approach, but I think it's important we bottom it out. At paragraph 215 of the judge's judgment, the judge said, sorry, it's 216, the judge says, in terms, having previously said that there was no variation, there is no evidence during the period 10th of May to the 18th of June of any material variations to or even negotiations of the equal parity agreement addressing the fact or possibility that Keane would not be a beneficial shareholder of the DRSL shares.
Yes, and I rely on
The only agreed material change was the removal of the performance conditions identified in the 27th of April email.
and we agree
Now,
with
where, well, I know you agree, but where and when did that occur according to the judge?
In terms of the removal of the performance criteria, the judge does say more in paragraph 73.
Well, he says there's no dispute that it had been varied accordingly.
And that's presumably before the 10th of May.
Yes. No one was able to recollect, at the beginning of 73, when or in what circumstances those criteria were dropped,
What was the evidence that they were?
or that they weren't applied. There was no evidence that any attempt to assess Mr. Keane's performance was ever operated. It would have started when he joined the firm on a day-to-day basis on, I think, the 10th of May, something like that.
But the problem was that the defendants were saying that that so-called agreed general package was just an outline proposal.
Yes,
So it's,
which the judge rejected.
but where was the evidence that there was an agreement to drop the performance criteria? It couldn't have come from the defendants
May
because
I-
they said it was just an outline proposal.
My lady, may I tediously go back to the bit of my skeleton that I was on when
Well,
I answered my-
we've talked about the witness statements, and I think we've not seen anything in the witness statements that deals with a variation.
No.
But what about the contemporaneous documents?
Yes, well,
Which documents do you rely on as demonstrating?
the position about documents is page 187 of the core bundle.
Well, you haven't identified which documents you rely on.
I was,
You just say a
I was-
category of documents.
My lady, I was addressing your ladyship on that when my lord
Yes.
asked me a different question.
Yes.
So 22, I said, one category of documentary evidence was legal documents
Yes.
and formal correspondence, and there's no criticism of the judge on
Well,
that.
but which documents are you relying on? Can you just
Well,
help us? It's
yeah,
all very
the-
well to show us your skeleton argument.
May I go on reading
Yes.
it, my lady? I'm
Well,
so sorry.
we've all read it now. It
No,
would really help.
we haven't come to the important bit.
I have.
May I just draw it to The other category was the email traffic, which was continuous and voluminous between the parties during the relevant period. Most of it was produced by the appellants. It was voluminous because it was contained in strings of emails which frequently overlapped, but which were all included in trial bundle C and core bundle without any attempt at editing. But at the same time, and this is the important sentence, the email traffic was frequently and obviously incomplete. No doubt because it had to be retrieved from files which were many years old, the most important dating from 2012. In other words, if one had to trail through trial bundle C, which I hate to tell the court occupied over 25,000 pages, and I think we both had to trail through it.
Well, that wasn't used at trial. There was a core bundle prepared.
Yes, I prepared a core bundle.
Because the 25,000 had never been agreed, it had just been put in by the claimant solicitors.
But one would expect if there was an email that evidenced the manifestation of an agreement to vary, the judge would have referred to it.
No.
Or you would produce it for us.
No. The result of this, what I've just described in the skeleton, para 24, was that when making his findings of fact on, for example, what had been orally agreed between the parties by the date when Mr. Keane actually started work at DRS on the 1st of May. I'm sorry, I misremembered that. It was the 1st of May, not the 10th of May. Or whether the draft partnership agreement and deed of adherence had ever been finally agreed and returned to Kingston Smith in August or thereafter. The judge had very good contemporaneous evidence in the form of a written record of the parties' spontaneous views in the form of their emails to one another. But that evidence was patchy in the sense that some of it was obviously missing. I mean, if one trailed through the whole email traffic for the relevant 6 or 7 years, for periods there would be a massive email traffic, and then there'd be several months for which there were no emails at all.
The problem with emails, just in the ether, is the finding in 216, without any indication of why or how, that the only agreed material change was the removal of the performance conditions identified in the 27th of April 2012 email. Now, to vary an agreement, you have to have, as I said several times, some manifestation of the variation. And what he's saying is, well, you, the defendants, are wrong about whether you entered into an agreement. You did enter into an agreement, manifested by the package, agreed package, and the equality agreement. That was on the 27th of April. Then on the 10th of May, Mr. Keane said, I don't want to pay so much tax. So everybody went away to think about it. And at some stage, there came into effect a revised, varied form of the two agreements, the agreed package and the equality agreement, on the 18th of June, because they had agreed to vary the initial package. Now, it's no good saying nobody really doubted that at some point those conditions were dropped, because just saying that doesn't tell you when an agreement that had actually been made by offer and acceptance was varied, which needs also to be done by offer and acceptance. And it might as easily support the idea that they didn't agree to drop the conditions. They simply proposed a draft in August which didn't have conditions in it.
We're still back in May, my
No, we're not. We're in between. We're very
Lord.
focused.
Call it the 18th of June.
Between the 10th of May and the 18th of June.
Yeah. Well, there simply isn't in the 25,000 page bundle
Anything.
there isn't anything between the 10th of May and the 18th of June that I can recall. And that is simply because that's an example of the patchy nature of this contemporaneous email evidence, which I've...
Can I just ask you about that? The, as you say, on the judge's findings, on the 10th of May, the issue arises about Mr. Keane having an interest in the shares, and matters are left on the basis that they're going to be investigated further. Then we know that an LLP agreement is concluded. You don't say, do you, that Mr. Keane acceded to the partnership on the 10th of May?
No.
So,
well, Mr. Keane says he became a partner at some date between March and June. He doesn't know when.
But it isn't your case that he acceded to the partnership on the 10th of May?
No.
But you do say he acceded to the partnership on the 18th of June?
Well, it was sufficient for the judge's purposes to conclude that he certainly was a partner by the 18th of June.
So what...
The judge did... Sorry,
go on, Matt.
Yeah. The judge simply didn't have the benefit of the sort of emails we've been looking at in the period between the 10th of May and the 18th of June, but he still had to make findings of fact on the balance of probabilities as to what happened.
So did he make a finding of fact that something happened between the 10th of May and the 18th of June where the investigations were completed and it was settled that Mr. Keane would accede to the partnership?
Well, 210. The evidence establishes, I find as a 209, I find as a fact the equal parity agreement wasn't renegotiated. General package wasn't varied or terminated 10th of May. There's no evidence that renegotiation, variation or termination occurred. Follows I don't accept the defendant's case that the parties abandoned the concept and replaced it with an LLP agreement to be construed without any reference to the equal parity agreement. The evidence establishes instead that Mr. Keane's 10th May 2012 statement was not the final word. It is plain, and I find as a fact, as explained below, that the parties decided, whether at the meeting or afterwards, it doesn't matter, but probably at the meeting, to investigate methods to achieve the equal parity agreement. That doesn't mean bring it into existence. That means work it, operate it, without producing a significant tax liability for Mr. Keane. And I reach that finding, and he calls it a finding, not only because of the deficiencies in the defendant's recollection, see summary below, and or because investigation as opposed to termination was the most probable outcome, as he's already said, but most importantly, because the decision to investigate is established by the contemporaneous evidence. I refer in particular to the 3rd of July email from Mr. Sargent to Kingston Smith.
I mean, just sorry, at the risk of it being difficult, I quite follow. The judge finds that there was going to be further investigation. So at this stage, 10th of May, Mr. Keane does not accede to the partnership. So what is it between the 10th of May and the 18th of June that shows that the investigations have been concluded, a solution has been agreed on, and Mr. Keane is acceding to the partnership?
Well, he says in 212 that his conclusions also supported by...
That's just about deciding to investigate. You can see that from the last sentence.
But the position could change depending on what resulted from the investigation.
Yes, so they've decided to investigate. So the question is, what is the thing that happens thereafter as a result of the investigations that the judge finds?
Well, nothing happened in a sense, in that the abortive discussions over the documents produced by Kingston Smith appear not to have reached a conclusion. In other words, my submission at the trial was on the balance of probabilities, looking at the effort that had gone into producing them and amending them and sending them backwards and forwards with nobody objecting to them. The likelihood is that they were signed. But the judge didn't accept that. He didn't make a finding that on balance of probabilities they must have been signed, because there's no...
They can't have been signed by the 18th of June.
No.
No.
August. It was in...
There was a question my lady asked and my lord asked. We're all asking the same question in different ways. Is what happened in that period of 6 weeks, which changed the contract and meant that Mr. Keane acceded to the partnership? Just what happened? And the answer, in a sense, nothing happened, really helps Miss Anderson.
No. The answer is that the performance criteria were appear to have been abandoned.
Well, what does abandoned mean in that context? I mean,
It means...
things don't get abandoned when you've got 10 people talking to one another by email. Somebody's got to say, oh, we're not doing that anymore. We all agree that he'll have a 20% share.
What abandoned means is that these 5 people are negotiating a relationship between them, which the terms of which they've been discussing. The 4 of them have been suggesting that for a period, originally 2 years, but then brought down to 1 year, Mr. Keane's membership of their association should depend on performance criteria. Then you find that Mr. Keane is actually in the office as a managing director on the 1st of May, and there is no reference to anybody applying any performance criteria. So you say, oh, well, they obviously decided to forget about the performance
criteria were measured in years and months, not
Sorry,
weeks. The performance criteria were to be measured in months, not weeks.
Yes, yeah, they were. Yes, they were. But
So what makes you say that they'd forgotten about it on the 1st of
because
May?
there's no reference in any document or anybody's evidence to the performance criteria being applied to Mr. Keane's results between the 1st of May 2012 and the 1st of May 2013.
Okay, so we now know that your case is that the judge was justified in finding this happened because of negative evidence, because there was no evidence of anything positive, so negative must be inferred. I mean, that's basically it.
Well, there's no evidence that this part of the original package was ever enforced.
No.
Well, that's consistent with that not being a contract, isn't it? It was not an agreement. It was a proposal that was ultimately not acted upon.
No, lady,
No?
with the greatest respect, I don't accept that. It's always a matter of pure common sense. My client was joining these people in a business which they were carrying on as a team of 4 to be a team of 5 when he joined, doing something that they were all very, very good at. And originally they cautiously proposed that he should join subject to a sort of, I don't know what one would call it, a trial period with performance criteria. But then, in fact, he joined only 3 weeks after this 10th of May meeting, and nobody ever mentioned performance criteria thereafter.
I see that, but resolution of the performance criteria issue doesn't solve the investigation point. Matters have been left on the basis that Mr. Keane isn't acceding to the partnership now. Things are going to be investigated.
No. He's not going to take shares in DRS Limited. That was his objection, and that was the tax point.
I follow that. I'm sorry. I thought you'd said earlier that you weren't submitting that Mr. Keane had acceded to the partnership on the 10th of May.
Well,
I mean, there wouldn't be much point in investigating if he had.
No. No, I mean, what I've already this morning, I think, drawn your lordship's attention to what Mr. Sargent said when he circulated the drafts produced by Kingston Smith. And he said, you'll remember the idea was that there would be a partnership, and Kingston Smith have now finally got round to producing some documents.
But I'm sorry to press you, but the 10th of May, as I understand it, Mr. Keane has not acceded to the partnership.
Yes.
Is that right?
Yes.
On the judge's findings, he has by the 18th of June. Now, whatever happened about the performance criteria, that required someone to conclude that there'd been enough investigation and now Mr. Keane was going to accede to the partnership. Now, is there anything about that?
Well, the evidence is the negative evidence that the performance criteria were never operated.
But the performance criteria don't bear on the investigation point.
Well, I'm not quite sure what the investigation point is. I mean, the investigation point, as I understand it, was whether some satisfactory way could be found of formalising Mr. Keane's 20% share in DRS, without which the LLP agreement wouldn't work.
I mean, the judge says in paragraph 210 that it was plain that the parties decided at the 10th of May meeting to investigate methods to achieve the equal parity agreement without producing a significant tax liability.
Yeah.
So matters are left on the basis that there's going to be an investigation. What is the evidence that that investigation had been concluded and they'd resolved that Mr. Keane was going to accede to the partnership?
Well, the evidence was, for example, that the so-called MIPers, those agreements under which the limited company began to claw back its rights under the LLP agreement in 2013 and 2014, wouldn't have happened unless Mr. Keane had an equal share in DRS by then.
But in terms of identifying something between the 10th of May and the 18th of June, where you say, well, look, the investigations were over, it had been decided that Mr. Keane should accede to the partnership. Is there anything?
Well, I mean, one piece of evidence from Mr. Keane, which it appears from various passages impressed the judge, was that he always understood that he was going in as an equal, and he wouldn't have used the word partner in the way a lawyer would. He was going in as an equal partner or participator or whatever one cares to call it with the other four.
And clearly the investigations were going to sort out how that could be done. But what's the evidence that it was done by the 18th of June?
Well, the judge concluded that it must have been done by the 18th of June. In in the passage that I think we've got open, which is the passage in the judgment following what we've just been looking at 209 to 12, where I've been drawing attention to the judge's finding that starting from the meeting on the 10th of May, the parties were investigating methods to achieve the equal parity agreement without producing a significant tax liability. And then I've already read 211 and 12, but then the important passage in answer to your Lordship's point is 213. It's not easy to identify precisely what happened after the 10th of May meeting. That's in part because Mr. Keane's evidence, he has little specific memory of what occurred. It's also because the findings of fact based on contemporaneous evidence are largely inconsistent with the recollections of the first 4 defendants, except to the extent of Mr. Sargent's evidence referred to in 211 above. 210 must be a misprint for 211. I hope your Lordship can agree with me on that. And the inconsistency starts with their failure to remember the agreed general package and the equal parity agreement as compared with the recollection of the 1st of March offer being extant and rejected. It includes their failure to recollect the decision at or shortly after the 10th of May to investigate solutions to the problem a significant potential tax liability would cause. Nevertheless, the fact the 6th of August email from Mr. Sargent evidences the fact that a new partnership of all 5 was discussed after the 10th May 2012 meeting. Lordship remembers Mr. Sargent's words to his fellow partners and Mr. Keane, not to Kingston Smith, were chaps, you remember that the idea was that we'd have a partnership. And it also establishes the evidence, the email of 6th of August also establishes the purpose of such a partnership was to resolve the problems caused at the 10 May 2012 meeting. While the investigations produce the potential solution of a partnership agreement, the evidence establishes that the discussions were not concluded. This is apparent from the fact that the draft partnership agreement and accompanying documentation were only produced after the execution of the LLP agreement, and these were never finalised. He's already dealt with that. The position, therefore, was that whilst the investigations were productive to a degree, they themselves did not produce a conclusion. There's no evidence during the period 10th of May to 18th of June of any material variations to or even negotiations of the equal parity agreement addressing the fact or possibility Mr. Keane would not be a beneficial shareholder. When he says there's no evidence, I mean, there's no evidence during that period for anything. It's one of the gaps in the email library. There must have been hundreds of emails between them during that period, to judge from their usual habit of communication, but there's no such emails have been produced. There's no evidence during the period 10th of May to 18th of June of any material variations to or even negotiations of the equal parity agreement addressing the fact or possibility Mr. Keane wouldn't be a beneficial shareholder of the DRSL shares. The only agreed material change was the removal of the performance conditions. Subject to that, the equal parity agreement remained extant when the LLP agreement was executed, but subject to the effect of Mr. Keane's 10th May statement about
Just briefly pausing there. So the investigations had to deal with the possibility that Mr. Keane wouldn't be a beneficial shareholder, not just a legal shareholder.
Yes, addressing the fact or possibility that Mr. Keane would not be a beneficial shareholder. I don't know what the judge meant by that. It would have made equal sense if he'd left out the word beneficial.
Well, not in the context of what I was discussing with you earlier, where you were saying, well, there would be no issue if Mr. Keane acceded to a partnership where he wasn't a legal owner of the shares,
Yes.
but he was one of those who co-owned partnership property.
That's right, and that's my point based on the wording of Mr. Sargent's letter of the 6th of August. Chaps, you remember the idea was, etc. So it's necessary to decide the effect of his 10th of May statement in the absence of not only of a concluded solution, but also of any evidence of a written or oral agreement varying the agreed general package to exclude the principles of equality, which were the foundation of the equal parity agreement.
Can I just ask you a question about that? Because the judge says repeatedly, well, the equal parity agreement had only been varied in relation to the performance conditions, something like that.
Yeah.
And we go back to the definition of equal parity agreement to paragraph 68.
Your Lordship will forgive me when I turn back to there.
And there we see reference to the agreed general package back in April. And then the judge says in the middle of the paragraph, for convenience, I will refer to these agreed equity and profit sharing provisions within the agreed general package as varied by the application to the LLP, the equal parity agreement.
Yeah.
So what we're concerned with is a feature of the agreed general package, which was what was set out in the 27th of April email. Is that right?
Yes.
So just going back to the 27th of April email, page 234, in the supplemental bundle, we're looking for the agreed equity and profit sharing provisions which produce equal parity, which are not dependent on the performance criteria. I mean, what's left? What is it that is the equal parity agreement?
Well, the equal parity agreement provided that subject to the performance criteria, your share in DRS profits would rise by a further percentage with the aim that you would have equal parity with the existing DRS directors after 12 months. And then once you, as things go forward, simply abandon the performance criteria and Mr. Keane joins the staff on the 1st of May, I think it is, as the 5th managing director, then he's achieved equal parity with the existing DRS directors without having to become a Companies Act director of DRS himself, which is the tax trap Kingston Smith have identified.
So you get it immediately without needing to satisfy any performance criteria.
Yes. to say where's a written agreement confirming all that, in my respectful submission, is entirely unrealistic when one is trying to establish the contractual relationship between five individuals who are in business together and who are treating one another equally within that business. And there isn't a hint in any of the documents until 2016, when Mr. Keane starts complaining that he's shouldering most of the burden. There isn't a hint in any of the first 4 years of the documentation of this firm, shall we call them, suggesting that there was any disagreement between them as to how the business should be run. There was never any doubt as to who was in charge, who was responsible for what, and there was never any suggestion that they were not all benefiting equally, receiving equal shares of profits and expenses, etc. And so if I can go back to the judgment at para 232, was there a partnership as of the 18th of June? And my lords, may I, before starting on that, invite your lordships to note, compare para 184 above. If we go back to 184, the fourth submission is that the absence of pleading of an agreement existing in May meant Mr. Keane was not cross-examined about such an agreement or the existence of a common law partnership. Now is not the time to address the existence of such an agreement in this judgment. That will be decided below. What he means by below is paras 232 to 247 below. Before we leave 184, I note that he says, as to the submission, I'm not sure I understand what's meant by an absence of cross-examination, and Miss Anderson's certainly cross-examined about the events leading up to the 10th of May meeting, the events of the 10th meeting, what occurred afterwards, and upon the documents relied on by Mr. MacDonald. Anyway, he addresses that question at para 232. It's been established within sections G1 to 3 above. Let me give you a note as to what he's referring to there. That's paras 201 to 218. Been established that as at 18 June, the agreed general package, including the equity and equal parity agreement, had not been terminated or, in the context of parity, materially varied. On the face of it, the LLP agreement remained interlinked for the purposes of its application and construction. Interlinked because the two agreements were there, and the LLP agreement only worked fairly if there was an equal parity agreement. That's one of my more general points. Mr. Keane had not rejected the agreed general package, including the equal parity agreement, by stating he wouldn't want to receive DRSL shares if that gave rise to a significant tax liability. Mr. Keane's 10th of May statement resulted in the parties investigating how to resolve the taxable event issue whilst implementing the equal parity agreement. Not a matter of contractual variation, it's a matter of finding a way to do it within the context of the equal parity agreement and without compromising its objectives. The parties discussed the solution in terms of Mr. Keane becoming an equal partner of a business which owned the beneficial interest in DRSL's issued share capital as an investment. That interest was already held by the partnership of the first 4 defendants established by the 4th of April. That's the VAT documents. However, those discussions were not concluded before execution of the LLP agreement. Whilst a draft partnership agreement deed of adherence were produced in late July, those documents remained in draft. See paras X to Y above. This means that as of 18th of June, the equal parity agreement had only been materially varied to the extent that parity with the first defendants 1 to 4 in equity and profit share, to use the original language of the 1st March proposal, would start immediately upon Mr. Keane joining the LLP, subject, however, to the effect of his 10th of May statement. As to that effect, it's plain from the evidence that the 1 to 4 defendants accepted that Mr. Keane could refuse to receive any interest in the DRSL shares should that acceptance result in a significant tax liability. And the LLP agreement also remains substantively in the same form as its 8th May draft, in that there was no change.
Well, there's no need to read these paragraphs out, Mr. MacDonald. We've read them very carefully. But
Yes.
I think this doesn't really add very much to the previous paragraphs. He's just summarising what he said.
Yes.
And there was no material variation except the variation to the performance criteria, and my lord has asked you extensively about the accession to the partnership, and there's no documents on which you can rely for that at that period.
No, what I say was that he was simply treated as, or it was assumed that he was or would be an equal partner in DRS from the making of the LLP agreement on the 18th.
Yeah. Okay. Well,
And
we
that
can
was
probably move on to the next point, because I think we've done that one to death, probably.
not to death, I hope.
No, of course not. It's a turn of phrase.
My lord, I'm not sure what point your lordships would like me to deal with next.
Well, I think you do have to deal with the pleading point, because Miss Anderson has dealt with it to a certain extent. Anything else you want to say about, I would say specifically, the events, the rejection on the 9th of May, which Miss Anderson places reliance upon, and anything you want to say about the interruptions, because despite the fact that we expressed the view this morning that we didn't think the interruptions won the appeal, I think we also said that the interruptions weren't very good, and so it would be useful to have your submissions, or any submissions you want to make, certainly on those points.
Well, just on the latter point, my lord, I produced a 26-page commentary,
which we saw, thank you.
The interruptions, and to go through that in detail would take quite a long time.
There's no need to go through that. No. And, if you want to just take that as read, that's absolutely fine.
I'll make some general submissions before I sit down.
Yes, okay.
On that head of the appeal.
Yeah.
But may I go back to pleadings?
Mm-hmm.
And may I start with my own skeleton argument because it's easier for me.
Yeah. You make a very strong point on the pleadings that the judge wasn't asked to rule on the pleading point.
Exactly. And that proposition, for which I relied on
I mean, do you want to take us to that case?
yeah, yes, I will, but let me just say by way of introduction, Hawkesworth. I mean, Hawkesworth is explained in the White Book as the authority for this proposition, which, anyway, I'll show you what the White Book says about it, and indeed what Hawkesworth itself said. And what we said in our skeleton under ground 1, or in response to ground 1, is contrary to the assertion under ground 1 in the notice of appeal, the respondent did not advance at the trial a case which was outside the scope of his pleadings. And then we said this has always been a partnership case. The claim form, Core Bundle Tab 8, begins, the claimant claims a declaration that he and the first fourth defendants have carried on the business of holding and managing the shares of the fifth defendant in partnership since about 20 August 2012, in order that partnership be dissolved and its affairs be wound up, etc. And that would have been immediately understood without more, in other words, without the particulars of claim, by the appellants as referring to a partnership under the set of documents drafted for them by Kingston Smith, which they were discussing with Mr. Keane in August 2012.
So not the agreed general package, but the later documents that the judge didn't find were ever executed.
Yes. The appellants would also have known without more that those documents included a draft partnership agreement between the appellants, etc., draft deed of adherence, draft partnership minutes. Quite apart from their own knowledge of those matters, the appellants would also have known from the letter before action, that's the last document in the supplemental bundle, that Mr. Keane didn't have signed copies of those documents, but that his solicitors were saying it was unlikely they'd been left unfinished, and that even then, if they were never completed, a general partnership would have arisen from the course of dealings between the parties, or alternatively the shares in DRS would be held by the appellants, who of course were still the registered shareholders, on a common intention constructive trust for themselves and Mr. Keane equally. And that alternative way of putting it was pleaded in the particulars of claim. And can we look at the particulars of claim in Core Bundle tab 9? That going back to the skeleton para 8, the first part of the particulars of claim pleaded that it was orally agreed between Mr. Keane and the defendants in March or April that Mr. Keane would join with them to operate the DRS business as a joint venture, intending and agreeing that they would each share equally in the profits and losses and the equity of the business. Discussion at that stage being that equality would be affected by Mr. Keane and the first to fourth defendants entering into an equal partnership, which would hold the entire shares of DRS. Going back to the particulars of claim at tab 9, it began, this claim concerns a joint business venture between the five of them in which they were equal participants, and participants is clearly, and I'm attributing this of course to my junior because I wasn't involved at that stage and had no hand in drafting these particulars, in which they were equal participants. Gary Keane was invited to join the venture in 2012. After discussions, it was agreed that he would have a profit and equity interest in the DRS business, which would have parity with the profit and equity interests of each of Sargent and the others. That foreshadows the importance attached to parity and parity agreement by the judge. And then we pleaded the background of the various parties, the LLP agreement, and summarises material provisions of it down to para 13. And then prior to May 2012, the DRS business was operated through the limited company. And then that's particularised in para 15 with quotations from documents with which the court is familiar. Then 15.2, after further discussions between Mr. Keane and Mr. McGloin, Mr. Sargent sent the email of the...
I mean, there's no need to read the pleadings out. Again, we've read it. I mean, your submission, as I understand it, is that what the judge found was within the ambit of your pleadings.
Yes.
And I suppose the most compelling part of that is 16. It was eventually all agreed, March, April 2012, that they would join to operate the DRS business as a joint venture with each of those 5 individuals, sharing equally in the profits and losses and in the equity. Is that it?
Yes, and at the end of 16, discussion at that stage being quantitatively affected by the 5 of them entering into an equal partnership.
Yeah.
Then 19, to ensure this equality.
I mean, what do you say to the point, I think the main point that Ms. Anderson made, which is that what is pleaded is that the agreement was reflected in the documentation of August, the draft documentation, and what the judge found was something completely different?
Well, my lord, that's taking a big leap. If I can just break that down into stages. At this stage, we had not seen the VAT documentation. It hadn't been disclosed, and indeed it wasn't disclosed until we demanded its disclosure 2 months before the trial, long after pleadings were closed.
Did you apply to amend when you got those other documents?
No, but we wrote a long letter explaining...
You've shown us the letter.
Yes, and then Miss Anderson, defending her pleading points, has to say, well, a letter isn't the same as a pleading.
No,
So-
what I don't completely get is why the VAT documentation makes any difference to this a pleading point. I mean, what is said is you pleaded that the agreement was the contained in the draft documentation, which was as good as signed, and it wasn't what the judge found. So you hadn't pleaded what the judge was asked to eventually find.
Well, what the judge did eventually find, to say that he was asked to find it is attributing far greater ingenuity to my closing submissions.
No, but
than
what
was
is
afraid.
said against you is that you jumped on his bandwagon, and that the pleadings simply didn't admit his conclusion. And what do you say to that? You say it's too late for that point.
I say it's too late.
It was all aired at the hearing.
It was all aired. Nobody was taken by surprise, thanks to our letter in November.
And do you, I mean, I asked Miss Anderson this. Do you say that the judge judge's interventions, because you all have read the whole thing, you were there indeed, made clear what he was thinking of deciding, or not?
Not.
Not.
Not. His interventions made clear that he was approaching the case meticulously, shall we say. I mean, he was. I'd very much like to go through those intervention points in detail.
But you don't think we would?
But,
and Mr. MacDonald, I may tell you, you're right.
but they do show. Well, I said I'd make some general points about them. What they show is that the judge was meticulously accurate time and again, and intervened in the most courteous way to assist the process of getting the relevant evidence out of the witnesses, or interpreting the documents on which he was being addressed. And but he did not, shall we say, show his hand.
Yeah, okay.
And when we got the judgment, it was a very major and time-consuming task to follow its construction, which was meticulous. But,
well, and it was meticulous, but there are aspects of it which do puzzle me anyway, and I can be perfectly clear about this. When he says, on the one hand, there was no variation, and on the other hand, there was variation.
Yes, well, there was no variation in terms of express formulation of variations in documents.
I mean, what bothers me about the judgment is that he doesn't seem to have asked himself, as sort of judges do need to do at each stage, what is the evidence on the basis of which I'm making this finding? He seems to have done what I think you submitted a little while ago, which is that he was looking at everything and deciding what was most likely to have happened. But that's a slightly different exercise from what judges are supposed to do, isn't it? Well, judges are supposed to look at the evidence and decide what evidence they accept and find the facts on that basis, not to throw, if I can put it this way, all the cards up in the air and pick the ones that they think are most likely. It's a slightly different exercise. You use the term balance of probabilities. Findings of fact are made on the balance of probabilities, but on the evidence. And I find that troubling in this case.
Well, let me just postulate to illustrate my point. A case where there is no doubt that at the end of the story a particular agreement has been achieved. It's recorded in some agreed document at the end of the story. The story is documented throughout by email traffic, but the email traffic is patchy, and in respect of some bits or episodes in the story, there is simply no email traffic at all.
And nobody can remember.
And nobody can remember, but the judge has to reach a conclusion. Either there was no agreement here, or there was an agreement.
But in that situation, the claimant, the person with the burden of proof, normally says, I am certain I entered into an agreement with the defendant at such and such, by such and such a time, and that you can see that I did from reading all these emails, but I understand that parts of the terms of it are not clear, but the terms were this. So that the claimant fills in the gaps in these situations. I mean, sometimes judges deprecate claimants filling in the gaps when their lawyers tell them what ought to be in the agreement, but they normally do. In this case, your client candidly said, I don't remember a thing. And that left the judge with a bit of a problem when the emails did not fill the gaps
Yes.
of what he wanted to find.
Yes, I entirely accept that. And the judge recognised it in his comments on my client's evidence, in which he made clear that he regarded him as a truthful witness in the sense that he was trying to tell the truth.
Even an unusual witness in some respects, because he didn't try and embellish his evidence at all. It was a very
No.
short witness statement, like the good old days.
Yeah.
I mean, you say, I imagine, and it's worth surfacing it at the end of the last day before I ask you how long you're going to be tomorrow, which I hope is not a long time. You say we should not interfere with the judge when he's done this meticulous exercise unless we are absolutely satisfied that he made an error of either clear fact or evidence or law. And whilst we may think we would have decided the case differently and we would have been more censorious about the lack of evidence, he wasn't, and it was open to him to do what he did. It was a pleaded case, and it was signed by a statement of truth, and there we are.
Yeah.
That's what you say.
Yeah.
Leave it alone. Court of Appeal should, in these situations, the judge is the finder of fact.
And he's obviously done his best to do his job.
There's no
fully
criticism
and
of the judge at all. I mean, he's done, as you say, a meticulous job, I think in quite short order as well. Yeah.
Yes, we didn't wait for it that long.
No. Okay, well, how long do you think you have got?
Well, Lord, I should go on with the second half of the particulars of claim.
Right.
Where we advance a constructive trust.
But do we need to look at that? I mean, the
Well-
constructive trust was dropped. Abandoned in your language, Mr. McDonald.
But
I mean, I think the paragraph that really matters to you is the one we've been looking at.
16.
16. I mean, you know, it's 4:10. We can adjourn now. We've got 2 days set aside for this case. I'm now sincerely hoping that we won't need at least the last part of that. How long do you think you'll be if you have overnight to think about what else you want to say? And we shut up, which we'll try.
yes, I think I would probably need another hour.
Right. Well, that's fine. And I don't imagine Miss Anderson's going to take us the rest of the day in reply.
No, as matters stand at the moment, I can't believe I'd be more than half an hour, 20 minutes.
Lovely. Okay, well, we'll be well finished by lunch, which is music to our ears, anyway, mine. And we'll see you all at 10:30 in the morning.